Welcome, everyone, to the Berkeley Center for Law and Technology's technology webcasts. We have, I think, something very unusual and exciting today. First of all, position that doesn't even exist in most law firms. I think you're gonna find this unique and something that takes a really kind of a global law firm with a massive presence like Baker McKenzie to bring. So with that, today we're going to talk about stock-based compensation in managing the unforeseen foreign tax issues, which is so central to many of the technology companies here in California. With us, we have Dr. Tien. Dr. Tien is, and this is the title that you won't find at many law firms, principal economist for Baker McKenzie, and he's based in their Palo Alto office. He works with global multinationals on the tax issues like intercompany pricing, economic valuation, and how those issues start impacting international tax issues. With him, we have, again, from the Palo Alto office, Himali Patel, who is an attorney in the Baker McKenzie office there in Palo Alto, which I think it's great to see, again, attorneys and economists together, not something you find at all the big law firms or even many of the big law firms. So Himali is in the tax practice group, and she's focused on domestic and international taxation with a real emphasis on the international tax planning around these types of transactions. So the reason I'm excited to see this group, because you don't find this kind of expertise in many places, and you don't find this kind of advice in many places. So looking forward to sharing this with our audience and really learning about more of this myself. So I will turn it over to the two of you. I think, Gene, you were going to pick it up from there. You have the slides?
That's right. Great. Thanks for that introduction. Yes, Himali and I work with many multinationals in the West Coast and globally to assist them on cross-border tax issues. And today we're going to be covering this relatively hot topic these days of tax issues associated with stock-based compensation. I think this has become a much more relevant issue because of, let's just say, that tax audit environment in foreign jurisdictions. It's been increasing over the past several years. And as many tech companies have mobile employees and international operations, it's become a much bigger issue as let's just say, tax authorities have really been trying to focus on digital and tech companies a bit more with their audits. We wanted to have this conversation to talk about the importance of looking at your stock-based compensation plans, your equity plans from a tax lens, because you'll be issuing, as tech companies, stock options or different types of equity to your employees who are going to be in foreign jurisdictions. They may have affiliates set up in those. And because you have key large liquidity events that are important, it's going to create some unforeseen tax consequences that will potentially cause issues that can be avoided through earlier addressing these issues earlier. Myself, I'm a transfer pricing economist, so I work with Himali and other partners in the Palo Alto office and along the West Coast to help companies sort of resolve some of these issues or mitigate them going forward. So I think, Himali, did you want to talk a little bit about, about the background for the granting of stock-based comp?
Yeah, thanks, Jane. So in our experience, the most common type of stock-based compensation that we see are RSUs, restricted stock units, though options are still fairly common amongst companies as well. And the main rationale for issuing stock-based compensation is that it's another form of compensation that does not necessarily require a company to be flush with cash. And private companies in particular may be cash strapped because they may not have the ability to quickly raise cash. And particularly in this economy, IPOs are down. And even for public companies, given the current interest rates, companies are not borrowing as much cash as they used to. So this allows a way for companies to compensate their employees and remain competitive even if they may be cash strapped nowadays. And some of the main reasons, other reasons we see employees prefer stock-based compensation is it's a way for employees to participate in business growth. It's also a way to keep employees around longer as they may wait for their stock options and RSUs to vest. And it's also tax favorable for employees to receive stock-based comp because the stock is not taxed up front, but rather when it is issued to employees. And even when the stock is issued to employees, any future gains on that stock, while it's held by the employees, is taxable as capital gains, which has a favorable tax rate. So a variety of reasons for why both companies and employees do like stock-based comp and keep issuing it even in this economy. And this is a common structure we see amongst companies nowadays, very simplified. US companies form their parent company generally in the US and have US employees. And the shareholders invest directly into the US parent company. But because for both tax and non-tax reasons, in jurisdictions where companies have a substantial presence or employees, they may choose to form foreign subsidiaries. And any foreign employees that are employed by the company may be employed by the foreign subsidiaries rather than the US parent. And this raises an interesting issue when it comes to stock-based compensation because it is the stock of the US parent company that the employees want. And that is because the stock in the US parent is what is liquid, and it also reflects the value of the entire business. So even though a foreign employee, let's say in Germany, may be employed by the local German subsidiary, when it receives stock-based compensation, it is stock in the US parent company it is receiving.
So I think a fun observation is that the same type of issue happens obviously for foreign parented companies that have operations in the U.S. Same thing. It's for that the possibility of getting the parent stock that matters to them. So same thing happens for foreign companies. And even if you don't have stock yet that's public, the future possibility or potential of it is really what a lot of these employees are interested in, and that keeps them and retains them in the company for a lot longer. So there's definitely some timing elements for when stock gets received by those employees, and that's that delay of tax consequences that Himali mentioned. Should we go to the next slide or stay on this one?
Sure. I get one more thing I would like to raise when it comes to this general structure we see with a lot of US companies is how are these foreign subsidiaries compensated? So with a lot of tech companies, for example, let's take an R&D company that performs research and development activities. If the foreign subsidiary, let's again take a German subsidiary, for example, is performing development activities on IP on behalf of the US parent company, then the US parent company has to compensate the German subsidiary at what we call in the tax world arm's length rate. And that means at a rate that third parties would transact at. And one general methodology we see a lot of these compensation to be structured at is cost plus method. So the German subsidiary would take all of its costs, so the cost of all the wages and salaries, any overhead, leases, training, etc., and mark it up by anywhere from 4 to even up to 16%. And the US parent would compensate the German subsidiary at that rate. So we have both stock going from the US parent to the employees, and then we also have income that the actual subsidiary earns from the US parent because we have cash going from the parent to the subsidiary as well.
Yeah, and so this really is relating this second part of it. So there's the element of issuing compensation to the employees, but then there's also this element of compensating or making sure that an affiliate that's set up in a foreign jurisdiction gets an appropriate arm's length return. That's really the purview of transfer pricing. And I think we will go into that in the next, a little bit more in the next slide. But this interplay of how equity gets to employees, but may be issued by the US parent and not necessarily recorded by the foreign affiliate and the foreign subsidiary. That's where there is this extra transfer pricing tax overlay that's on something. So in a typical world of startups and founders, you have a set of R&D people that happen to be located in some jurisdiction. You, as a US company, decide to for various reasons, set up that affiliate. You are compensating the employees, but sometimes that compensation goes through the affiliate in one way or the other. And some of the compensation is coming from the US in terms of the equity plan. And this mismatch or this potential way of getting the equity to those employees is what can create some interesting tax issues. As we move on to the next slide, the issue that we are seeing or that companies need to be aware of that are in this space is that foreign jurisdictions have seen that mismatch, and some jurisdictions think that you should include let's say for this US R&D case, you should include the stock cost that the US might be earning or might be incurring that then is given to the employee, and say, well, that should be part of the cost plus that Himali mentioned that is earned in the foreign affiliate. That creates more tax, and that's one of the issues or one of the reasons why companies like we just had a call with some companies in operations in Europe where they say that's actually a fairly hot issue right now, where they're trying to just add more of the cost into the cost base and create a bit more of the markup. But I think that this issue becomes even more than just, well, how much extra plus is being earned in a foreign jurisdiction, because some tax authorities are getting more aggressive in trying to deem that the entire compensation that may never have been on the books of a foreign affiliate is income that the foreign affiliate should have had in and is an expense that the foreign affiliate should have, and they try to deny the deduction for it. So that's another big trend that we're starting to see in a handful of jurisdictions that are going after tech companies.
Yeah, and you mentioned the deduction point, Jean. So the stock is issued by the US parent. So there's two questions. The first is whether there is a deduction available for the stock in the US. And by that, we mean if we're considering stock-based comp as a form of salary expense, is there a tax deduction available in the US such that the US taxable income decreases? And in the US, the general rule is that only services that are performed by employees that directly benefit that US company are eligible for the tax deduction. So in this example, the US parent company would get a tax deduction for stock-based compensation that is issued to US employees, but it would not get a tax deduction for stock-based compensation that's issued to foreign employees. And the second question then is, well, could we get a foreign tax deduction for that stock-based compensation? And this is where it gets very tricky because there is no overall standard practice, and this varies country by country. A lot of countries, though, do allow a deduction for that particular country if the foreign subsidiary that's located in that country bears the burden of the stock-based compensation. And to bear the burden, the foreign subsidiary would then have to pay the US parent for that stock-based comp. So we have cash flows going in both directions now. We have the US parent who has to pay for services that are performed by the foreign subsidiary on behalf of the US parent. And this is, for example, the cost plus markup methodology that we discussed earlier. But then we also have the foreign subsidiaries reimbursing the US parent for the stock-based compensation that's issued to its employees so that it is deemed to bear the burden of that compensation. But here there's a lot of local rules on what type of compensation may actually be deductible in any given country, the amount of deduction available in any country. And like I said, there's no standard rule or practice, and it really varies country by country. Some countries are very formalistic, and they do require there to be an intercompany agreement that documents that the foreign subsidiary is bearing the cost of the stock-based compensation. So there must be an intercompany agreement, which we refer to as a recharge agreement, and there must actually be a cash payment from the foreign subsidiary to the US parent in that case.
Yeah, and I think there are also some other interesting nuances as well in terms of how, in what form, what manner that foreign affiliate receives it. So in some jurisdictions, if you, let's say you have a recharge, but the shares are dilutive, or or if the shares are non-dilutive, there are different treatments that might happen so that you can't take a deduction if you don't have actual treasury shares. But in other jurisdictions, you can definitely get a deduction even if you don't buy back the stock of existing outstanding stock for it. So those are some of the additional issues from a deductibility standpoint. The other nuances that are happening right now as it relates to the global regime of transfer pricing are perhaps even messier. Let's just say it's this issue of stock-based compensation is being debated in different jurisdictions' courts as well, because there aren't as many clear rules and legal guidance on the inclusion of stock-based compensation as an expense of a foreign affiliate. So we see some jurisdictions trying to deem a fictional expense in some instances. Thus, for cost plus entities, they deem a larger cost base to have things included. Some jurisdictions then say, well, we deem this additional income and we're going to deny the fake income, deduction to the fake income in this case, because you don't have the right agreements and the right structure in place. But that's not the case for necessarily every jurisdiction. So to reemphasize the point that Himali mentioned, it is a case-by-case situation. There are some positive cases out there as well in a few places in Europe where there are either good rules or like a recent court case in Ireland that allows the transfer pricing, certain transfer pricing regimes to seem like they're winning out. But it does depend on the local law. Local law matters more than the good arguments that what you have about, well, U.S. is the one bearing the costs.
Yeah, I think the Irish case is very interesting, Gene, and it may provide a sort of precedent that maybe other countries may follow. How do you see the Irish case sort of expanding to other jurisdictions, or if any other countries are citing to that case?
Yeah, I think that the general trend up until the Irish case for Matheson just last year, I suppose, was that um, a lot of the jurisdictions had some type of they were looking to another case that was not in many of the taxpayers' favor. That case basically was sort of taking a bad position on stock-based comp and essentially not allowing deductions to be made and imputing some additional income. But the Matheson case was looking at where or who the actual costs are being borne by. And in that case, the U.S. multinational that was the one bearing the stock-based compensation cost. Thus, it seems to mean that from an OECD transfer pricing principle perspective, there now is at least one good case out there using these more or less global arguments, economic arguments that if you look to who actually is getting the benefit and who's actually incurring the cost. In that case, no recharge was made. The U.S. was bearing those costs, and the U.S. is arguably getting the benefit for it. So I think that this is at least one data point that's out there using these type of economic arguments that's really helpful for could be helpful for companies in with that right kind of fact pattern. But I will say that the fact patterns definitely differ. Some companies want to have recharge arrangements for cash repatriation strategies. Others want to have recharge arrangements because they have that alignment so that they can take a deduction in a foreign jurisdiction. But then you have to go through other hoops of like, well, what does the local law say? And what were your original objectives for this, for the plans? So it gets pretty complicated pretty fast.
Yeah, and just on that cash repatriation point, we've been seeing this used as a common method to bring cash back to the US, particularly companies that have many, many employees located abroad, and they have a lot of cash located abroad as well, in a foreign subsidiary. To bring that cash back to the US in the form of a dividend could often be subject to dividend withholding tax, which, in some countries maybe 0% or 5%, but in other countries maybe 30%. And when you're talking about millions and millions of dollars, it really starts adding up. So one of the reasons a lot of companies do want this sort of recharge arrangement is so that the foreign subsidiary could pay the U.S. parent for the stock-based compensation and bring that cash back up to the U.S. parent in a non-taxable manner, and not have to rely on dividends instead, which may be subject to dividend withholding tax. And you mentioned that also that the Irish case was more taxpayer friendly. I think the worst case scenario would be a situation where for the stock-based comp issued to foreign employees, we don't get a deduction in the US, but if the foreign law also does not allow a tax deduction in the foreign country, but the foreign tax authority still tries to include the stock-based compensation within the cost plus base. So in that case, you would have more income in the foreign country, but you wouldn't have any deduction for the stock-based comp. So that's the absolute worst case scenario that we've been seeing, but hopefully we're hoping the new trend is to be a bit more taxpayer friendly. But as Jean said in the beginning, this is really a hot topic for tax authorities worldwide.
Yeah, and I think the one last point I'll kind of mention is that the other thing that's really interesting is that for companies that are starting out on the tech side, what this hot topic really kind of indicates is before you or as you're setting things up with your with those first plans and your first agreements for your foreign subsidiaries, you really should be thinking about these issues early on so that you don't run afoul or create some bad facts down the road. But then also for companies as they get more mature and they start saying, hey, I need cash abroad, like the cash repatriation strategies that were mentioned, you also want to make sure that you don't run afoul of these particular issues that we're starting to see on those for those type of transactions. So it's sort of the life cycle of technology companies. The facts are going to be slightly different, and you need to just prepare yourself in advance, set up the right type of agreements, getting the right kind of employment plan in place, just to think about things a little bit further in advance, just to avoid the future audit issues that are coming up. Wayne, I think that might be maybe it, but thanks for your time, everybody.
Oh, no, thank you. It's fascinating, and it's really interesting to see how much more complex this has gotten over the course of my career. Just a few years ago, people probably wouldn't have even asked these questions. So it's interesting that you're have this level of depth and knowledge in the area, and I think it's great that you're willing to share that so people at least can spot the issue and know that they need to call some experts on that, which is often half the battle as a lawyer, is just getting people to recognize that bad things can happen if you don't make a phone call. So this is a great program to really drive home that point. So again, thank you all, and thank you to Baker McKenzie for allowing you to donate your time to us here at Berkeley.